Hello and welcome to the Disability Law Q&A with me, Martin Willemse. I'm a partner at the firm of St. American LLP and the Western Canada Disability Practice Leader. Please send us your questions through all the social media platforms, and I'll get to them as soon as I'm able. We deal with disability claims all day, every day. So if you have questions, I'll do my best to respond to them. We've got offices in Ontario, Alberta, and British Columbia. We represent clients with denied disability claims, denied critical illness claims, denied mortgage disability claims, and denied life insurance claims throughout Canada, other than in Quebec and the territories. So if you have questions regarding any of those, please forward them to us and I'll respond to them. One of the first things that have come up, which often is a question, is what do you do if you have returned to work after being on disability, in other words, having an approved disability claim? You engage in a graduated return to work, and then you find that you struggle. Can you go off work again and request the insurance company to start paying you again? With all questions like that, I always refer everybody back to the policy. The policy is a contract, and the policy defines the relationship between you and the insurance company and defines what can and cannot happen. In most policies, there is something called a recurrence clause. I'm now speaking about long-term disability claims. The recurrence clause, depending on the wording of your policy, in general would be 6 months, meaning that once you've returned to full-time duties, if you go off work again due to the same condition within the first 6 months, then you may request the insurance company to reopen your claim under the recurrence provisions of your policy. That means that if that were to be approved, you would not have to qualify again for the elimination period. In other words, there will be no waiting period. The insurer will still just start to pay you benefits again. Depending on how far or how long you've been paid benefits, it would be deemed to be the same claim as the initial one. Having said that, you have to consider what the definitions are in your policy and whether you have a recurrence provision. If this is a situation that applies to you, and if you have questions, you're welcome to contact our firm. When we get contacted, we usually have questions assessed by lawyers, and we offer free consultations. In other words, if your claim were to be denied and you contacted us to discuss what your options are, we would at that time hopefully be able to review your denial letter that you received from the insurance company, if you have the policy and medical records, and then we can discuss with you what your circumstances are after having reviewed those and to decide what your options may be. In order to do that, you can then make an informed decision as to whether to proceed with an appeal process or whether to pursue a legal claim. We represent clients with respect to legal claims, and we work on a basis where we seek out for our clients the best compensation available through the legal claim process to allow our clients to focus on their treatment and not to have to deal with the insurance company directly. More questions coming in. Okay. The first question is from Esmeralda, that comes through Facebook. My insurance company has been very vague about why they are denying my application. They keep mentioning my limitations and saying I don't have enough documentation. What am I missing? This often happens where an insurance company may deny a claim, and it's one of the main reasons. They may say to you that the evidence is not sufficient, or that there is no objective evidence, or that the doctor's reports are vague. When a claim is denied, I again urge you to contact us and we can discuss with you what we see in the records, what the shortcomings may be, and what your options are. Generally, when you submit a claim, you want to have your doctor complete an attending physician statement. In that statement, there will be various questions that the doctor has to respond to. For example, I've used this as an example many, many times. If you have a condition related to depression or other mental health illness, and your doctor says, my patient has depression and they cannot work, your claim is going to be denied. What you have to do when you submit a claim to the insurance company is prove why your condition is so severe that it impacts your ability to perform the essential duties of your occupation. Diagnosis is important. The most important thing in any disability claim is functional impairment. In other words, what are the restrictions and limitations that would prevent you from performing the duties of your own occupation? In our example of depression or even anxiety, what would the restrictions and limitations be? Remember, many people with those conditions are able to work. So you have to provide evidence how your condition impacts your ability to perform those duties. It may be inability to focus, inability to concentrate, poor memory, cannot multitask, cannot comprehend new information. Your sleep may be impacted. Your medications may impact your cognition as well. You may have anxiety attacks, panic attacks, you may have social withdrawal, social isolation, you may not want to deal with the public, you may have days where you don't want to get out of bed, low mood, low motivation, poor energy, fatigue. All of those things should be considered globally to consider whether the person is unable to perform the duties of their own occupation. So if the insurance company, when you say, why are they denying your application, they really should be telling you that they've assessed the claim and these are the reasons why they are denying the claim, but they often don't. So again, you're welcome to contact us and we can review with you the denial letter and then discuss what your options are. Because with a doctor's note, not enough. A doctor will have to outline in detail why you are restricted and limited from performing your duties. As you can see on the screen, you can go to disabilityrights.ca for more information. Okay. The next question. Morgan asks, can you request to have a claim reopened under the recurrence clause if you did not do a graduated return? That's an interesting question. And it's interesting because this is what we started off speaking about today when we opened the show. It depends on your circumstances. So number one, Morgan, do you have the policy? Does the policy provide for a recurrence clause? If you speak about having your claim reopened, are we speaking about a long-term disability claim? Often, the recurrence clause would provide that if you return to work full-time, meaning you're performing your full duties, full-time hours, if you then go off work within a defined time, usually it is 6 months, then yes, if it is due to the same condition, you should be able to request them to reopen your claim under the recurrence provision. But it really depends on those questions, your specific circumstances, and what your policy provides for. If you don't have the policy, you can request it from Human Resources or from the insurance company as well, or you may have it through some other means. But generally, a recurrence clause does provide that if you return to work full-time and you go off work within the first 6 months, then you can, due to the same condition, then you can request them to reopen the claim under the recurrence provision. Franny5 says, if my doctor says I will only ever be able to work 2 to 3 hours a few times a week, would I still receive LTD? There's no way I can live on that amount of income. Franny, this is a very good question. And I often speak about this in the context of somebody who may be working and may have difficulties in performing their duties due to a medical condition. They then start to work fewer and fewer hours to the point that they find that they can no longer do that. Then they go off work, and then the insurance company, when they submit their claim, denies their claim because they say they did not have enough hours or did not work enough hours at the time when they stopped working. Therefore, they were not actively at work as that term is defined in the policy, which literally means you did not work enough hours to maintain your coverage to submit a claim. So if your doctor says you will only ever be able to work 2 to 3 hours a few times a week, if you are already receiving long-term disability benefits, would you continue to receive those benefits? In the perfect world, one would say yes. Whether the insurance company will continue to agree to pay you benefits, that's the bigger question. But remember, when you have a disability claim, there may be two definitions. The first one is you have to prove that you're unable to perform the duties of your own occupation. If you can only work 2 to 3 hours a week, and that's it, you should still qualify for benefits. Then the definition changes. Then the definition will be you have to prove that due to an illness or a condition or an injury, you are unable to perform the essential duties of any other occupation, or it may be defined as gainful occupation. There may be a percentage given in that gainful occupation definition, which would require that In order for you to remain able to receive benefits, you would have to prove that you have a condition that prevents you from performing the duties of any other occupation for which you have the transferable skills through your education, your training and experience, and that would allow you to earn 60% of your pre-disability income. Let's say you're able to work 2 to 3 hours per week in any other occupation, but that is the maximum of your capacity. Yes, you should still qualify for benefits because if there is no percentage defined in the policy in the any occupation phase definition, in other words, it simply says you must prove that you are unable to perform the duties of any other occupation for which you are qualified or may become qualified by means of your education, training, experience. And there's no section that speaks about how much the percentage of what your income should be from your pre-disability earnings. Then we default back to the common law position, which may provide that if you cannot earn the same as your LTD benefit in the any occupation phase of your policy, let's say you can only earn 20%, then arguably you should still be able to receive benefits because you still meet the definition of disability under the terms of your policy. So I'm hoping that the insurance company is paying your benefits, but if they were to deny it, even though you could work 2 to 3 hours per week, please contact us and we can discuss with you what your options are. There's always this friction between having to go back to work because there's a mitigation argument at the side of the insurance company where they would want you to return to work. But on the other hand, if you do return to work, then they may say, well, we believe that you can go back to work full time now. So it's often done if you do and done if you don't. I'm not saying this is the same for all cases. Some insurance companies do approve people while they do have some capacity, but often cases are denied. If a person engages in the graduated return to work process, because the expectation is that they should advance and improve, have work hardening treatment so that they can increase their hours, so that the insurance company would find that they no longer are disabled within the meaning of the policy. It all depends on what your circumstances are. If you do engage in a graduated return to work process, it is crucial, it is imperative that during that time you see your doctor on a very regular basis. The reason for that is if you start the graduate return to work process, if your symptoms start to worsen or if you develop new symptoms, you want to make sure that during that time you're reporting that to your doctor so that if it is the case that you find you can no longer participate in the graduate return to work program because your symptoms have become so severe that you have to go off work again because you cannot perform the essential duties of your occupation, you would want your doctor to support you. Or it may be that your doctor would be the one saying, you should stop this program. It is worsening your condition. You're eroding all the benefits or all the gains that you've made during the time that you were off work. And now you may be faced with a much longer or a prolonged absence from work due to your efforts engaging in the graduate return to work program. There is an expectation on the part of the insurance company that you do engage in that process. In other words, that you do participate in the graduate return to work program if you are able, and generally if your doctor supports that. But again, make sure that you see your doctor regularly so that if that program fails or your participation in the program is no longer viable, that the doctor can provide an informed opinion and support you by giving the reasons why you should stop and why the graduate return to work program is actually not giving you any benefit. Question from Adam. My LTD claim was approved, but they say they are doing ongoing assessments. Does that mean they're going to cut me off soon? What should I expect during this review process? Will they cut you off? I don't know. If your claim has been approved, please don't sit back and expect that that's going to continue to be the case. You should continue to see your doctors regularly. Under the terms of your policy, you have to be under the regular care of a physician, and secondly, you have to receive appropriate treatment for your condition, meaning that you follow through with your doctor's treatment advice and you see your doctor regularly. If medications are not working, speak to your doctor about that. Let's use mental health again. If you're taking an antidepressant and it's not working or it's creating side effects, discuss that with your doctor. The doctor may try a different medication, or the doctor may recommend counseling, or the doctor, after a period of months, may say, well, I don't know what's happening, this is not working, let's refer you to a psychiatrist. If you do all those things, then the insurance company cannot criticize you for not being under the regular care of a physician, not being proactive in trying to get better. So do that on a regular basis. Ongoing assessments may be that they are gathering records. It may be that they are having one of their in-house doctors review the records to decide whether they agree that you are unable to perform the duties of your occupation. Or they may decide to send you to what is referred to as an independent medical examination. Make sure the only thing that you can do is continue to see your doctor regularly, report to your doctor your ongoing struggles. In other words, your restrictions, your limitations, and what your symptoms are. Do that on a regular basis. If you report improvement, put it in context. What does that mean? I feel better today because I made it out of the house versus the last week I couldn't even get out of bed. If you simply say I feel better, the insurance company is going to jump on that. So put it in context. What does it mean? Better compared to what? Because those clinical records of the doctor will become available to the insurance company. They will request it and they will review them, or they may have the in-house doctor review them. So when you see the doctors, make sure that you report to the doctors your ongoing symptoms. Be proactive in exploring other treatment in order for the insurance company to hopefully not deny your claim, because you are doing everything that is required of you under the terms of the policy. If they denied you, again, you're welcome to contact us, because we do offer free consultations to review the denial of the policy and discuss with you your options. Again, go to disabilityrights.ca, as you can see on the screen, for more information. Okay, next question. Naisha L says, my mother's insurer is really fighting her about her claim. She has PTSD from being attacked and assaulted by a co-worker. How much can they make her re-explain the problems? It's very traumatic. That's a tough one, because obviously with PTSD and complex PTSD, reliving the experience is not advised. I would advise your mother. So there's another thing that popped out as I was reading that, and I'll discuss that in a minute, but I would advise that your mother speaks to her treatment team and they put in writing why it is ill-advised and not recommended for your mother to continue to speak to them about what her experience was and why it would be a potential worsening of her condition as a result of their actions. Submit that to the insurance company. She should not be reliving it. She should not be speaking to them about it all the time. They do functional telephone interviews where she can discuss with them, and they've probably already done this. There's no reason to keep speaking about it, especially if a doctor says, considering this condition, reliving it, either through appropriate counseling with a counselor who is experienced in complex PTSD, is not appropriate. So if you put that in writing and have from the treatment providers and send that to the insurance company, hopefully they will back off and simply approve the claim. You're welcome. If they don't, if they deny it, reach out to us, as I said before. One other thing, I'll use this as an example. Reading that again, I'm currently off on LTD. Sorry, that's the wrong one. My mother's insurer is really fighting about her claim. She has PTSD from being attacked and assaulted by a co-worker. That leads to the question, has a WorkSafe claim been submitted? If it hasn't, I would expect the insurance going to insist on that, because under the terms of the policies, for most part, if WCB benefits are payable due to the same disability, those form an offset from what the insurance company would have to pay. And generally, the WCB benefits are higher than the LTD benefits, which means that they may wipe out the payment itself. Not the approval or denial of the claim, but the payment will be reduced to zero if WCB benefits are payable and if they are higher, which they generally are. So consider that, but I won't weigh into that much more. I'm just using that as a general example, because often when there is a workplace incident, insurance companies do push people to apply for WC benefits, especially if they have a mental health illness of a workplace incident, including bullying and harassment. If you want to look back at previous videos that we've made about this, because there's a lot of discussion about bullying and harassment in the workplace, and when you have to apply for WCB benefits, and the difference between being disabled from your own job versus your own occupation. Okay, next question is from Darian, and that comes through YouTube. I'm currently off on LTD, and my insurer has told me that if I don't apply for CPPD, then I need to start a return to work. Is this something my insurance can force me to do? That is not appropriate. Whether you're applying for CPPD versus being able to return to work, those two things are irrelevant. They're not the same. So can the insurance company force you to apply for CPPD? No, they cannot force you. But under the terms of the policy, and it depends on the wording of your policy, for the vast majority of group policies, CPP disability benefits are deducted or offset dollar by dollar from your LTD benefit amount. Many policies do provide that if you are eligible for other sources of income and you do not apply, then the insurance company may estimate what the amount is that you would have received from that source, meaning CPPD, and they can estimate that and then deduct it from your LTD benefit if you refuse to apply. So can they force you? No, but they can take steps depending on the wording of the policy to the extent that they may even estimate the amount and deduct it from the LTD benefit amount. But saying if you don't apply, then you have to go back to work, but that's not how this works. You're either disabled or you're not. And if you go back to work, it's because you're not disabled. So CPPD, the test is you have to prove that you cannot perform the duties, well, rather, it is you have an illness or a condition that is number one, severe, number two, prolonged, and number three, that prevents you from engaging in any gainful occupation. If you meet that test, then CPP disability benefits become payable. It often is the same under the any occupation phase of your policy, the same test to some degree. That's why insurers often push people to apply if they approve them into the any occupation phase. Now remember, with CPP disability benefits, there may be some benefit there because your LTD benefit may not increase every year if you don't have a cost of living allowance benefit. But with CPP disability benefits, it does increase every year. Also, if you have children under the age of 19, or if they are older and they're dependent on you because they're going through university or college, you may also be eligible for CPP disability benefits for your children. They call the child benefit, which under the terms of the policy may be an indirect offset. If the insurance company denied your claim, you should still be receiving CPP disability benefits because they don't reassess cases on an ongoing basis like the insurance company does. Unless, of course, you're able to go back to work, then generally the payment would stop. So there are some benefits to receiving CPPD. Okay. 2 more questions. So Amy says, I've been on short-term disability for 5 months due to mental health condition. My employer is now pushing me to return, but my doctor says I'm not ready. Can they force me back before any doctor clears me? Generally, that should not be the case. I should also mention that we do employment law Q&A sessions. The next one will be on Wednesday, September the 17th, which is tomorrow at 1 p.m. Eastern Standard Time. So any employment-related questions, I would recommend that you post on that forum as well. But under the terms of a policy, a short-term disability claim or an LTD claim, if your doctor supports that you remain unable to work, no, you should not be pushed back to work. You should have your doctor put in writing why you are unable to return to work, what your restrictions and limitations are, and what the risk would be of a premature return to work. But I'm also cognizant of what you can provide, what information you can provide to an employer versus an insurer. If it is the insurance company requesting you to return to work, you can provide more information. With an employer, I believe the information that you can submit to them should be limited. They're not privy to the diagnoses, but they are privy to restrictions and limitations and the prognosis. But I do urge you to, if you do have further questions on this, to reach out to us. You'll see on the screen in a moment. You can go to disabilityrights.ca, or you can contact our firm and ask more questions and be put in touch with somebody who can respond to your questions. Okay, one more question. Betty L says, I've been on LTD for the last 3 years, but I'm about to receive some money from a will after my mother passed away. Is this considered income? Do I have to tell my insurer about it? My knee-jerk response to questions like this, and my default position, is always go to the policy, review the policy, and see whether or what the offsets would be. But offsets, for the most part, would be other sources of income that you may receive or be entitled to receive as a result of your disability. It may also be things, whether it's a direct offset or an indirect offset. It may be retirement pensions that you could receive, or benefits that you could receive through you being a part of an association. It would be CPP disability benefits. It would be benefits that you get through some automobile insurance plan, WorkSafe benefits, severance, other sources of income that you may receive through employment, money that you receive from a will because your mother passed away would not be an offset in my mind. Also always with the caveat, depending on what the wording of the policy is, but I've never seen a policy, ever, and I've been doing this for many, many years. I've never seen a policy where proceeds from a will would form an offset. It cannot be, because it is not paid as a result of your disability, and it's not paid because it's some sort form of employment income. So no, I don't believe it as income, but to be clear, because we cannot give legal advice on these forums, you're welcome to have us review your policy. I'm not feeling confident what it would say, but I'm happy to review the policy with you to make sure that it's not an offset, but I cannot see how it could be. Do I have to tell my insurance company about it? It's not a source of income, so I don't see why it would be a requirement to do. With all of that being said, I think we've got to the end of our question session. Thank you for all the questions. I hope you enjoyed today's session. As I said, our next employment law Q&A will be tomorrow, which is Wednesday, September the 17th, at 1 p.m. Eastern Standard Time with Sefton Libran of our firm. Now, I always get this wrong. 1 p.m. Eastern Standard Time would be 10 a.m. Correct, yes. 10 a.m. BC time and 11 a.m. In Alberta. So please tune in if you've got questions, and we look forward to seeing you through our next disability law Q&A. Thank you, and I wish you all a good day.